Mr. Melly answer, coming back. I suppose so. Miss Smith, permission to show him. I suppose so. Statement again. Miss Smith, permission to show him. Statement again. Question by Ms. Smith. Yes, Mr. Glass, I'm going to give you question by Ms. Smith. Page 6. Mr. Glass, I'm going to give you page 5 and page 6. And review those pages and look when you're done. Start in the middle and read done. Answer, Is that a yes? Answer, yes. Is that a yes? Question, did that refresh your recollection? Yes. Question, did that refresh your recollection? Question. Answer, okay. Somewhat. Tell us what you somewhat question. Okay, answer, tell us what you somewhat remember. Question, if you recall, answer, I just did. I'm sure you went to question. If you recall, you said you weren't sure you went together. Refresh your recollection. And then I asked you to refresh your recollection. Did you say refresh your recollection? Answer, whether or not you left together. I was grieving. I'm not sure what nobody did. I was grieving. I'm not sure what you mentioned. Not you mentioned. Let's see. I pointed out to you someone was the person that was wearing the jacket that you identified as Melly was carrying something on the jacket that you across his side or was carrying something across his side.
TSA is a place for those who are looking.
We have many different layers of security that all work together. We're here to protect the traveling public and to keep the nation's transportation systems secure.
Sir, no. Question, do you know what was in the satchel? Okay, answer, I don't. Question, okay. Do you recall seeing anyone else in the satchel that night in the studio? Answer, that was 5 years ago. I don't recall. Question, is there anything that can refresh your recollection as to whether or not anybody else was wearing the satchel? Answer, I suppose so. Question, if I were to show you that video again, would that refresh your recollection? Answer, I suppose so. Question by Ms. Smith. Publishing states 7. Question by Ms. Smith. You want to start at 2:19:01. State 7. Pause at 2:19:01. I'm going to pause at 2:19:13. Anyone else? Does the video refresh your recollection as to anyone else that was carrying a satchel? Question. Answer, yes. Question. If anyone was carrying a satchel. Answer, and that's Answer, question, and that's Christopher Thomas. Answer, yes. Question, did you ever have any business relationship with the person referred to as Track? Answer, no. Question, okay, do you know who Track is? Answer, not really, or answer, not really, or answer, I don't know who. Question, do you know of him? Answer, yes. Question. Do you know him? Did you see Track on October 26th? Question. Did you see Track on October 26th, 2018 at any point? Question. Do you recall giving a statement, specifically the statement that I previously provided here today, that I previously provided you here today as a detective in this case? Please here today to the detective in this case. Answer. Question. You have to answer out loud. Question. Answer, yes. Question. That was a statement that you gave to Detective Moran and another detective, I believe, in the Indian River. Is that correct? Yes, it could be. Question. Would showing you that statement refresh your recollection as to anything regarding your interactions with Track on October 26, 2018? Answer. I don't know. I don't know Track. Question. No. My question was, would showing you the statement refresh your recollection as to any time you saw Track on October 26th of 2018? Answer, no. Question, one moment. You said you ended up back in Gifford at some point in time on October 26th of 2018. Answer, yes. Question, and do you recall where Melly was at the time you went to Gifford? Answer, I don't remember. Point at Frito's house, do you guys all leave, meaning you yourself, everybody that you previously identified that was there? Answer, I don't recall. Question, you don't recall leaving? Answer, I don't recall leaving with anyone. I don't know where I left. I don't know how I left. Question. Okay, just to clarify my question, so you mentioned you left. When you left for Gifford, was anyone else at Frito's house? Answer, I don't know. Question, do you recall Melly making these statements in your presence while you were at Frito's house? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to anything Melly told you while you were there? Answer, I don't recall. Question, so you remember them leaving the house at least once, correct? Answer, yeah. Yes. Answer, yes. Question, all right. Now, when they came back, do you recall any conversations that Melly had in your presence that first time after the first time? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to those statements? Answer, no, wouldn't. Question, all right. Do you have a Facebook page back in October 26th of 2018? Answer, I believe so. Ms. Smith, I'm approaching counsel with what's been marked as state's quadruple I, was previously shown permission to approach the witness. The court, you may. Question by Ms. Smith, Mr. Glass, do you recognize these two pages that I'm showing to you? Answer, I guess so. Question, and this is a Facebook, do these statements reflect a Facebook conversation? Answer, they do. Question, is this a fair and accurate representation of the conversation that you had on Facebook? Answer, it is. The clerk states quadruple I will be marked as states 83. Permission, Ms. Smith, permission to publish? The court, you may. Question by Ms. Smith. Mr. Glass, can you see that document in front of you? Answer, yes. Question, all right, where it says author, can you read that for the members of the jury? Answer, you want me to read it?
Excuse me one second. Then you and I keep the message of one of your members needs a restroom break, so we'll take a short recess. Do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in presence. We'll be back in minute reading shortly, as soon as we're done with the restroom break, all right? Thank you. Thank you. Let the record reflect the jury stepped out. Mr. Devens, you need a restroom break?
Yes, sir.
Can you arrange that, Mr. Devens?
Yes, sir.
Thank you. We're in recess. Hopefully forecast.
Answer, yes. Question, is this the guard gate you testified to at Melly's house? Answer, yes, yes. Question, do you see that screenshot at timestamp 3:51:31? Answer, Question, is that a yes? Answer, yes. Question, do you see yourself inside that red Mitsubishi vehicle? Answer, yes. Question, and were you located? Answer, and where are you located? Answer, passenger. Question, do you recall going through the gate, going through the procedure of going through the gate? Answer, yes. Question, so you get through the gate, where do you go next? Answer, to the house. Question, all right. And can you tell us, you pull into the house, is there a driveway in the house, in front of the house? Answer, yeah. Question, are there any other cars parked in that driveway when you get to the house? Answer, no. Question, all right, did you see the gray Jeep that you left the studio with at the house? Answer, no. Question, all right, so what do you do when you get out of the vehicle? Answer, what I remember, I just went upstairs and went to sleep. Question, okay, and you said upstairs, so the house is how many stories? Answer, a couple. Question, okay, so you went upstairs to where specifically to sleep? Answer, to Judy's room.
If I was looking for a creative way to make some extra income from home, I'm talking about $10, $20, or $30,000 per month consistently, as a real estate investor, what would I do? Well, let me tell you what I wouldn't do. I wouldn't become a wholesaler. I wouldn't go out there.
Where it was if it was not upstairs. Answer, I think it was like front first room when you come in the house. Question, was Melly at the house when you got there from what you can recall? Answer, no. Question, did you see Melly at any time in the house? Answer, no. Question, all right, so you go upstairs in Judy's room and what do you do? Answer, crash. Question, crash meaning? Answer, go to sleep. Question, okay, at some point do you wake up? Answer, yeah. Question, and why? Answer, phone calls. Question, okay, safe to say your phone was getting a lot of phone calls blowing up? Answer, yeah. Question, and at some point you answered the phone, correct? Answer, yeah. Question, okay, what do you do in response to the phone calls? Answer, I answered it when it kept ringing, and yeah. Question, and so what do you do in response to getting that phone call? Answer, I ended up at the hospital. Question, all right, do you recall which hospital that was? Answer, no, I don't. Question, do you recall what city you were in at this point? Answer, I was in Broward. Question, what city, not the county? Answer, Miramar. Question, do you know if you went to Miramar Hospital? Answer, I don't know what hospital it was. Question, so you get to the hospital, what do you find out when you get to the hospital? Answer, that Anthony Christopher were deceased. Question, okay, and obviously at that, let me not say obviously, but at that point in time, what do you do or how do you react to that news? Answer, grieving. Question, okay, do you stay at the hospital? Answer, not long term. Question, where do you go after the hospital? Answer, I ended up somebody's house. Question, all right, do you recall whose house that was? Answer, I don't know whose house it was, but I ended up there. Question, let's start about with the city. Do you recall what city that house was in? Answer, Miramar. Question, do you recall if it was in the same or different area than where Melly's house was? Answer, it looked similar. Question, and just to clarify, was it the same or different house than Melly's house? Answer, different. Question, where did you go when you went to that house? Answer, what do you mean? Question, like where in the house did you go? So you go to the house, where do you go? Answer, nowhere. Inside the house, I was in the back. Question, and would your statement refresh your recollection as to whose house you were at? Answer, maybe. Ms. Smith, Your Honor, please permission to approach. Ms. Smith, Your Honor, permission to approach. I'm going to show defense counsel the same statement, page 4. Question by Ms. Smith. Same procedure, Mr. Glass, if you could just review page 4. Answer, I don't see nothing about a house here. Question, if you could just read the entire page and when you're done, let me know. Have you finished reading that page? Answer, yes. Has your memory been refreshed as to whose house you were at? Answer, I still don't see nothing about a house here. Okay, I'm going to now show you what's in evidence at state 62. Do you recognize individuals in state 62? Answer, yeah, I do. Question, okay, who are those individuals? Answer, Melly and another dude, Frito. Question, you said Melly and another dude, Frito? Yeah. Do you know Frito's name or any other nicknames? Answer, that's all I know, Frito. Question, Frito. Do you recall ever going to Frito's house? Answer, just that time. Question, just that time being what time? Answer, after I left the hospital. Question, and for the record, what is Frida wearing in the photograph? Answer, a shirt, a white shirt. Question, okay, so after the hospital, you went to Frida's house? Answer, to the best of my knowledge. Question, and what were you doing at the house? Answer, still grieving. Question, who took you to the hospital? Answer, the cameraman. Question, do you recall his name? Answer, Drew. Question, and do you recall who took you from the hospital to Frida's house? Answer, same person.
Gentlemen, thank you. Please be seated. Let the record reflect the importance of the vetted, the council, the assistant state attorneys, and the ladies and gentlemen jury. When we go, I think we will go on the readback of Mr. Glass. Madam Court Reporter, could you continue with the readback, please?
Question by Ms. Smith. If you can read that, what does it say next to author? Answer, Fargo. Question, what does it say before Fargo? Answer, Fetty Fargo. Question, do you see where it says Fetty Fargo? Answer, I see it. Question, okay. And who's Fetty Fargo? Answer, it was me. Question, who was that? So was that was that how you identified yourself on Facebook? Answer, kind of, sort of. Question, who were you having these conversations with? Answer, right now it looks like I'm talking to myself, like I was texting. I don't know who I sent it to. Question, do you see where it says participants? Answer, okay, so texting Melly. Question, that was page 1. I'm going to now publish to page 2. I'll publish it in part since it's a little small. Can you see that in front of you? Answer, yes. Question, I'm going to scroll up. What was the purpose of you having this conversation with Melly? Janelle Demons. Answer, I don't know. Just everything was questioned. Question, when you got to Gifford, were you looking for answers? Answer, not just me. Question, were people kind of pressing you for answers? Answer, correct. Question, and did they have any impact whether or not you reached out to Melly? Answer, I don't know what you mean by that. Question, so again, you said that people were looking for answers. So did you reach out to Melly looking for answers? Answer, I did. Question, is that the gist of that conversation on Facebook? Answer, is that just? Question, meaning the gist of the conversation was that the purpose behind the conversation and the general conversation that you had with him? Answer, yes. Question, do you know who Jamie King is? Answer, I don't know who she is. I know of her. Question, do you know her relationship? Answer, his mom. Question, do you know the relationship between Jamie King and Anthony Williams? Answer, I don't. Question, if I were to show you a copy of your statement, would that refresh your recollection? Answer, nope. Question. Sorry, Ms. Smith, and 1 moment to confer. Nothing further at this time. The court, counsel, thank you. Any cross-examination of this witness? Mr. Howard, yes, sir. Good morning, ladies and gentlemen. The jurors, good morning. Cross-examination by Mr. Howard. Question. Good morning, Mr. Glass. Mr. Howard, Your Honor, do you mind if we could move the monitor from in front of the witness's face? The witness, I do, I mind. Mr. Howard, okay. Would you mind, Your Honor? The court, I don't mind. Is there a specific issue that you have, Mr. Glass? Yes, I do. Ms. Smith, Judge, can we approach sidebar? This is direct continued cross-examination by Mr. Howard. Good morning, Mr. Glass. Good morning, sir. Answer. No verbal response. Question. There was no response to this. Answer, no. Question. To your text on the first page. Answer, no. Question. On the second page, the state was discussing that essentially you were inquiring of Mr. Melly what had gone on because you were trying to get information. Answer. Yeah. Question. And you see a conversation here where you get a response. I want to direct your attention to. Answer. I see it. Question. That statement. It says, I showed them niggas more love than they parents, right? Do you see that? Answer. I do see it, bro. Question. Thank you. And the next statement by the next message in sequence is again from Melly. It says, TF. What does that mean? Answer. You tell me. Question. Okay. What does that mean? Answer. I don't know. Question. Okay. So you were having a conversation and you didn't understand the response? Answer. I don't know what TF means. Question. So you didn't understand that response, correct? Answer. I just said it. Question. Okay. Then there's another one that says, men, tell them fuck that if they think I did some shit like that. We can go to war. Nigga, you know I would never do nothing like that. Do you see that? Answer. Yes, I see it. Question. Okay, so state had mentioned that you got arrested recently and charged criminally, correct? Answer. Correct. Question. And on May 30th, not too long ago of this year. Answer. Yeah. Question. And one of the charges that was made against you was obstruction of the service of the execution of a search warrant. You're aware of that? Answer. I am now. Question. Pardon me? Answer. I am now. Question. So you got charged and you had no idea what you were charged with? Answer. Correct. And you are now on pretrial release? Answer. I bonded out, sir. Question. Okay. And while you're out on bond, you are of the opinion that if you don't come here, answer, I'll be in jail. That's the only reason. The court, excuse me, what happens is when they make objections, you wait before you answer. Objection overruled. The witness. Got you. Hold on just 1 second. I'm gonna reread that portion. Okay, and while you were out on bond, you are of the opinion that if you don't come here, I'll be in jail. Ms. Smith, objection, Your Honor, relevance. The witness, that's the only reason. The court, excuse me. What happens is when they make objections, just wait before you answer. Objection noted, it's overruled, proceed. The witness, got you. By Mr. Howard, question. You're of the impression if you don't come here and sit in the chair and testify, you're gonna go to jail. Answer, correct. Question. Okay, there are several instances which Ms. Smith, prosecutor, that questioned you, showed you a statement that you previously gave. Remember that? Answer, yes. And you told us you remember seeing me in the deposition not too long ago. Answer, I said what? Question, you remember seeing me last week on Friday? Answer, yeah, I remember. Question, and you recall at the time that your statement to the detective was a few days after the incident? Answer, you say, do I recall? Question, that's what your recollection was at the time? Answer, yes. Question, a couple of days after? Answer, a couple days after. Question, and now after seeing the statement, you realize that it was 4 months later, right? Answer, you say what? You said what? Question, the statement you gave to police. Answer, you're telling me it was 4 months or asking me. Question, pardon me? Answer, are you telling me or asking me? Question, I'm asking you. Answer, that don't make sense. If you asking me, I told you it was there. It was 3 to 4 days after they died. Why are you asking me if it was 4 months if I just told you? Question, okay. So in the statement that you gave to police back then, you claimed that you had gone into the red vehicle in the rear seat, right? Answer, that was 5 years ago. To the best of my knowledge, that's what I said. Question, you're saying the statement was a few days after, right? Answer, what did, question, the statement that you gave to the police was a few days after the incident? Answer, yes. Question, and you said then that you had gone into the rear of the red vehicle? Answer, to the best of my knowledge, yes. Question, and then you watched this trial unfold on TV over the last couple of weeks, right? Answer, no. Question, you didn't watch any of this trial? Answer, I watched it, but I didn't watch it unfold or whatever you're trying to say. Question, okay. You watched this on TV, this trial? Answer, on the phone. Question, and you saw a video of yourself get into the red vehicle, right? Answer, correct. Question, and you learned that the statement that you gave a few days ago, a few days after the incident was gone. Let me reread that question. And you learned that the statement that you gave a few days after the incident was wrong. Answer, because I said I was in the back and I was in the front. Question, yes, exactly that. Answer, that piece? Question, yes, that piece. Answer, okay, yeah. Question, you forgot where you sat in the vehicle a few days after? You can answer. Answer, answer what? Question, that question, is that correct, sir? Answer, did I forget? Question, did you forget? Answer, I could have made a mistake and said I was in the back and remembered that I was in the front. Question, so when you told the law enforcement officers that you had gone into the back of the vehicle a few days after the incident? Answer, that's what I thought to the best of my knowledge. Question, that's what you thought? Okay. And when you got to Melly's house that morning, you had a key? Answer, did you have a key? Question, no, I didn't. Did you? Answer, no, I didn't. Question, who had a key? Answer, I don't know. Question, do you know of anybody having a key to Melly's house? Answer, I don't know. Question, okay, but you did gain entrance to the house that morning after you left the studio? Answer, yeah. Question, and then you said you just went and crashed and went to sleep in Judy's room, right? Answer, factual. And you were awakened by your friend Drew? Answer, I did not say that. Question, were you awakened by your friend Drew? Answer, I said I was awakened by phone calls. Question, did you ever make a statement differently where you claimed that you were awakened by Drew? Do you understand the question, sir? Answer, I don't even remember getting asked a question. The court, all right, restate your question. Question, did you ever make a statement to the police? Answer, I don't recall. Question, okay, do you recall now being asked this question and giving this answer? Question by the detective. Then, and so when you first saw Drew, when did you see him? Where did you see him at? Your house or Frida's house? Answer, at the house in Miramar, at Melly's house, okay? He woke me up. It was like, come to the hospital. You said that? Answer, I don't recall. Question, don't recall? All right. When we spoke to you last week, you said you were awakened by phone calls from Christopher Thomas's mom, right? Answer, plenty of phone calls, different people. Question, pardon me? Answer, different people. Question, different people. And the one that you answered was Ricky. So you were awakened by a phone call from Ricky. Answer, to the best of my knowledge.
When the sawdust settles and the engine finally roars, The thing you care about most is a job well done. But when you get your tools from Harbor Freight, something about the job feels a little different. Your wallet. Because we believe no matter what you're working on, you need high quality tools at a great price. And that's what we have in stock here. So whatever you do it for less at Harbor Freight. Quality tools, lowest prices.
That. Answer, when I smoke. Question, and when would that be? Answer, when I smoke. Question, how many times a day? Answer, twice, 3 times maybe. Question, and on the night in question, before you got to the studio, on the day in question, you had smoked at least 2 joints, right? Answer, that's your guess. Question, that's what you said, right? Answer, I don't recall. Question, okay, and when you got to the studio, you were smoking, correct? Answer, possibly. Question, were you or weren't you? Answer, that was 5 years ago. Question, you forgot? Answer, I don't recall. Question, and you were drinking Hennessy, I believe, or do you not recall that either? Answer, it's possible. Question, possible, but you don't recall. Answer, I don't. Question, okay, so you don't recall much from that night then, do you? Right? Fair? Answer, right. Question, and when you got in the red vehicle and left, you went to sleep in the vehicle when you left the studio, right? Answer, yeah. Question, and you didn't wake up until you got to the guard gate? Answer, I woke up when we came to a stop. Question, you did not wake up until you got to the guard gate. Am I right or wrong? Answer, I woke up when we came to a stop. It was at the guard gate, yes. Question, have you ever seen track with a gun? Answer, it's possible. Yes, maybe so. Question, okay, so you don't know of any friction between Melly and Anthony Davis at any time. Anthony Williams at any time. Answer, not that I know of. Question, and you don't know of any friction between Melly and Christopher Thomas at any time. Answer, not that I know of. Question, you didn't see any friction at the studio that night of any kind, did you? Answer, I didn't. Question, you did? Answer, I didn't. Question, with respect to your daily marijuana regimen, did you smoke before you came here today? Answer, I did not. Okay, I have nothing further, Judge, thank you. The witness, I should have. The court, counsel, is there any redirect, Ms. Smith? Briefly, your judge. Briefly, Your Honor. Redirect examination by Ms. Smith. Question, Mr. Glass, did you live in Broward County back in October of 2018? Answer, I did not live here. Question, okay, when did you come in relation to this incident in Broward County? Answer, I was picked up probably, I don't know, I was picked up on the weekend or something like that. Question, so how would you, I guess, date how long you were here prior to the incident time frame? Answer, 3 days, 2 days. Question, okay, so you were not a full-time resident of Melly's residence? Answer, I was not. Ms. Smith, nothing further. This witness is excused? Yes, Your Honor. You may step down.
That concludes the readback of the witness Glass's testimony, so you may now retire and continue with your deliberations. Thank you, ladies and gentlemen. let the jury step down. Counsel name will defend. Counsel, I have another question that the jury posed when they came in to read that. And the question reads, what is the conversion to 1 meter equals how many feet?
We rely upon the testimony. We rely upon the testimony.
Everybody agrees? Can I do that just in writing here? Is that all right with everybody?
That's fine. I'm sorry, Your Honor. I think you should say you must rely upon the testimony.
That's what I started to write.
I'm sorry.
No, you're right.
I'm sorry. What did you just say? I'm right.
More than once I'll say it. You must rely upon the testimony. Anything else you want to say? Stay, all right?
That's fine, right?
There are foods here, so we're gonna utilize this time for lunch. You hear that?
Lunch?
Lunch.
When should we be back?
You tell me, I mean, where you going? You buying?
Yes.
The 30-minute window thing is out the window.
No, I mean, take 30 minutes, that's fine. Just be available.
Yes, sir. You have our numbers.
All right, they agree with you, Madam State?
Yes, sir.
All right, so we need to avoid it. All right, thank you.
Thank you, sir.
For recess.
The readback of Travion Glass's testimony is now complete, so the jury has heard it all. We are going to start taking your questions now, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, Twitch, TikTok, and Threads, and we'll get to as many of them as we can. Michael Bryant, host here at Law and Crime and also an attorney, is here with me. Offie Patterson is an attorney here with me as well, and Mina Lona, a SiriusXM host, is here. Thanks to everybody for being with us today. So let's get to our first question. Smurf Duh Gemini from Twitter, Michael, why did the phone say mobile the whole time? And we know that we had to stop at red lights.
Why did the phone say, oh, as if it was moving? Is that their question?
Yeah, Melly's phone said mobile the entire time they were driving. And then it says outside stationary when you exit the vehicle, according to the prosecution.
Yeah, I'm guessing that the technology, as you know, I'm not a big fan of it, but I'm guessing that it requires a certain period of time actually motionless before it registers as something other than mobile. That'd be my best guess.
All right. Let's get to this next question. This is for you, Offie. This is from @JustChillin' and we've heard from @JustChillin' quite a few times from Twitter. Do the defense attorneys in this panel think that the defense picked a good strategy with Melly taking Melly out of the crime scene, or do they think there could have been a better strategy?
So I think they had to choose. So I think they wanted to rely on their alibi witness. And their alibi witness said he wasn't there. They said he was at the house at the time of the murder. And I also think that they didn't have to get a crime scene reconstruction expert, and it saves them having to just add explanations because we knew Melly was likely not going to testify. And, you know, putting him there would have required a lot of explaining and a lot of testimony. And you wouldn't want to open Melly up to too many questions if he was going to testify. But I think it wasn't necessarily the best strategy at the end of the day because the 9807 number, I do believe, was sufficiently tied to Melly. We believe it was his. And I think that if you follow the phone, you follow and you find out and you learn how the murder took place. So I don't know if it's going to work out, but they use that strategy because of their alibi witness.
Mina, I'll send this next question to you, and it's about Travion Glass. The testimony we just heard read back by the clerk for the jury, and he was with everybody at the recording studio that night. So Cindy Hedden asks from Twitter, I just answered part of the question for you, Mina, but who is Travion Glass? I haven't been able to watch much of this trial.
Travion Glass is a childhood friend of Juvie. They've known each other for over a decade. He was in that red Mitsubishi, which is the other car that was leaving the studio the night in question. He was staying at the house as well, Melly's house. So he has a lot of ties to not only the people who have passed away, but also Melly and this YNW collective. So he was one of two people that were actually in the red car that testified and gave their account. So basically friends of the people who were affected, and they were there so they can give us their opinion on or their recollection of what they remember seeing.
Michael, this next question is from you. It comes from @Reba05 from Twitter. As legal experts, do the questions asked by the jury lead you to determine which way the jury is leaning?
You know, it's always tempting to put probably more into the questions than is the reality. But of course, you want to use that as any sort of insight as to which way they're going. Hopefully, you interpret it as something that helps your side, but that isn't always the case, and sometimes it's totally irrelevant. In this case today, we already know they wanted to get a statement made by Bortland Henry at the hospital, and then they changed their mind and said, no, we don't want that. So what does that tell you? Does that tell you that they've decided amongst themselves that the statement means nothing? And we believe it's the statement in which he first said, hey, this all happened as a result of a drive-by. Does it mean that they believed his statement, don't need to hear it again, or they don't believe it and they don't need to hear it again? So the short answer is you just never know, but you try to interpret it as best you can for your side.
All righty. Well, we're going to sign Offie off. So, Offie, thanks for being with us today. We really
Thank you
appreciate
for having
it. And
me.
we're going to take a quick break. When we come back, we are going to have Terry Austin come on and tell us what happened in that courtroom and take more of your questions. So, stay with us. I'm Anjanette Levy. You're watching Law and Crime. We'll be right back.
Join large-scale battles with military vehicles. The online action game War Thunder has received a major update. Direct Hit.
Welcome back. I'm Anjanette Levy, and thanks for being with us here on Law and Crime as we take your questions in the YNW Melly double murder trial. There was a readback of testimony requested by this jury. They are now deliberating yet again the fate of YNW Melly. Let's bring in our panel, including Terry Austin of Law and Crime. Terry is down there at the Broward County Courthouse. Terry, bring us up to speed about this readback and what was going on in the courtroom as it was happening.
Well, first of all, we heard a question from that jury. It was the first question, and they asked about the call logs for 9807. And then they also asked about witness testimony, which you just mentioned, Anjanette. We heard some of that. And they were asking for Trevion Glass to be read back. And also Michael, and we would remember him, it's Michael Kelly. He's the one who was the crime scene investigator. He talked about trajectories. And they also asked for someone called, Cortland, but they got the last name wrong. They said Sutherland. That was corrected later, and it was Cortland Henry. Then they said they didn't need that testimony because it was the investigation. They wanted to hear a little bit more about what he said, but they decided, no, we don't need that. So ultimately, the bottom line was the judge said, look, we can read to you what the testimony was as far as Trevion Glass is concerned. It will take a little bit longer for the court reporter to pull together the testimony of Michael Kelly. And so she's working on that. But we did hear her read the entire testimony. And frankly, a lot of it was, I don't know, I don't recall, and I don't think this is going to refresh my recollection. We mentioned this before, and I'll just end with this. I do think the parts of his testimony that the jury wanted to hear was who was in that car and whether or not what Melly was wearing was the same as the beginning of the night. And so it's really going to be up to the jury to determine whether or not he is credible. And I will say that part of the defense did read when they were doing their cross-examination about why he was there, and he was subject to charges if he didn't come and testify. So that jury is going to have to determine whether to believe his testimony over what they've seen from the defense side.
There was also some testimony. I guess they asked him if, it would refresh his recollection to see his prior statement about whether or not Melly left and came back at some point that day. Was that right, Terry?
That's right. And he said, no, it's not going to refresh my recollection. So from an evidentiary standpoint, if the witness says it's not going to refresh their recollection, then it doesn't get to be read in, and it wasn't read in, and he didn't say anything more about that particular issue.
All right, just briefly, Terry, we've got the first question coming out to you, the first question of this block. This is from Tracy Dye 00437-887 from Twitter. Who was escorted out of the courtroom today during the jury questions, if you know?
Yes, I actually saw that. It was packed this morning on both sides of the courtroom. And on the victim side of the courtroom, they get an entire side reserved for them, of course. And there was a phone that went off. And when that happens, the court personnel is very strict about that. Those Broward County officers will take a look at where that ring came from, and immediately the person is escorted out. There's no conversation. They get a point towards them, and then they sort of get a finger out and they're escorted out. And frankly, I've seen them say, you're not coming back. And so we'll see what happens. I'll look to see if that person comes back. But yes, it was one of the individuals who was sitting in the audience today who got escorted out for her phone.
Very interesting. All right, let's get to more questions. And this next one goes to Michael Bryant. Michael Jorgensen from YouTube, who is a frequent question asker here. Does the longer the deliberations go lean more and more toward a hung jury? Do the questions give you any indication of what the jury is starting to think?
Yeah, I think in general, if we can generalize here, longer could mean they're hung up on something. In this case, where are we now? 5 hours, a little more than that, not counting the readback period. That's not long enough to really get to that point. Maybe, if we're having this conversation Monday or Tuesday, maybe. And it really depends on whether it's a big split. Is it one person they're trying to, put in a headlock and change their mind? You just don't know at this point. And what we've heard, as I mentioned before, and Terry just mentioned, that statement given by Bortland to the police was first and then concern and then not. And now we know that the Trevion Glass testimony in its entirety was important. I think if we hear them ask for Adrian Davis
Davis.
to read back his testimony, that may be enlightening. To me, that would totally laser focus their concern, or somebody's concern, one of them, 11 of them, on this whole alibi. And was it believable that Melly was not in the car when the shooting took place, that Melly was back home just sleeping away, and he got the bad news right along with everybody else? That would be critical to me.
Mm-hmm. So this one, Mina, I'll send over to you. It is from Ron Janae. I'm hoping I got that one right from YouTube. Do you guys think that the jury is confused because they asked to restate someone who didn't even testify?
I think it is and can be confusing. There are a lot of names and a lot of moving pieces. And then I think the other confusing part is also their government names versus their street names. You know, Jameson Francois versus Track. I think that can be all very hard to keep up with if you're not writing it down. I mean, even in my notes, I made little, you know, I have all these graphs and things going on just to keep track of all the moving pieces. And it does become confusing. And it's very evident from them even getting Cortland Henry's name wrong, which is literally a co-defendant. So he's one of the main names, the main people that are also involved in being accused of this murder, and they can't even recall his name. So I can see them being very confused in there, and I wouldn't be surprised if they continue to ask for more of the testimony from other witnesses. And also, we have to mention the prosecution had 27 witnesses. So to remember all the members of YNW, and then their adjacent friends like Fredo Bang, and then also all the 27 people that the prosecution put on the stand, it can be a lot for a jury.
It is a lot, and there are a lot of names. So I could totally see them getting the last name, you know, Cortland Sutherland versus Cortland Henry mixed up. Terry, you know, that brought a question to my mind. Were any of these jurors, or I don't even know, were they allowed to take notes at all? And if so, did some of them take notes?
Yes, they were allowed, Anjanette, and yes, some of them did take notes. Not many, though. You can't really see below the rail, but I know for a fact because they're leaving their notes down. I would say probably 4 of them are taking notes at this point, and perhaps they didn't catch the name. I mean, Mina is absolutely positively correct. If you don't have that list written down and you don't have the alternate names written down that each of them has, I think it's very hard to follow. And so I think altogether, all of them deliberating may not have had that full name. And remember, his name is Cortland and Bortland and, you know, Henry. So he's got multiple names. And so it may have been difficult for the jury to remember.
And just speaking from personal experience, I found myself going back to the testimony. I found myself going back to a lot of the testimony and re-listening, and they don't have that advantage. So I can see them being very confused by just listening to the testimony once.
Yeah, I always do that too. Like at night, I'll go back sometimes and listen to it again. I just make sure I didn't miss anything and that I heard everything right. So they do not have that advantage, and it's tough. Our next question comes from Facebook. Michael Asti Bryce asks, I have 2 questions. So we've got a 2 for you, Michael Bryant. If the defendant is found guilty, what charges would Cortland Henry face? And second, do lawyers get paid extra for a win in court?
That's interesting. You know, I guess, let me answer the second question first. It kind of depends, because in civil cases, a lot of cases are contingent, and a win generally means you're going to get a bigger share of money from the win. Criminal cases, you know, not so much. You may get more hourly fees as a result of some work that you've done. And a lot of folks who are paid hourly charge a certain amount up to trial, and then at trial, the fee goes up, the hourly rate goes up. But it's not necessarily tied to a win or a loss. You can still pay the same amount if you lose. What was the first part of the question? It was, the charges that Cortland might face. Well, we know he's now basically looked at as an accessory after the fact, although I think he is also charged with the first-degree murder. It's almost a felony murder analysis there, because there were murders that took place while he was in the car. I don't think they're going to put the gun in his hand. So the biggest claim against him, and it relates to that hospital statement the jury was waffling about whether they wanted to see or not, is what part he might have played in any cover-up. If the drive-by shooting was just a cover-up, what did he have to do with that? I think his concern, if the jury, especially if they convict Melly, his concern is going to be as an accessory after the fact. If they acquit Melly, that may change the dynamic a little bit, and it'll be interesting to see what, if any, other charges might be leveled against him. It would be very interesting.
I'm going to take this next question because I can do it really quickly. So from YouTube, Team Pretty 20 asks, how much time is he looking at for manslaughter? If he is convicted of manslaughter, that lesser included offense, it's a maximum penalty of 15 years in prison, and then I believe something like a $10,000 fine. So we'll knock that one off the list. Nicalia Lancaster from YouTube, Mina, asks, what would be the reasoning for them wanting to hear Mr. Glass's testimony?
It was very crucial. I mean, this is where we found out that Melly was at Fredo's house after the alleged murder. This is where we found out that Melly had a change of clothes and he had shorts on. It was very crucial and important. And it was also our first time hearing from someone that was actually there the day of the crime. He was in the studio they were all in. He could testify and speak to the fact that there was no conflict in the studio. That was actually a question that I had. What happened in the studio? Did anything happen in the studio that led to some kind of conflict that could have resulted in these two young gentlemen being murdered? I wanted to know that, and he provided those answers. He said there was no conflict in the studio. People were sleeping. That's why we left. This is also the first time that we find out that it's a 12-hour prepaid studio session, which to me is very important, because to me it says Melly went into that studio that day to be there for 12 hours. So now I'm questioning, was this premeditated? Because it was a prepaid 12-hour studio. So his testimony was very crucial, and it allows us to go to that day and go in that studio and see what happened and see how Travion Glass recalled Melly's movements even after the alleged murder.
All right, keep the questions coming to us, and we'll take more of them when we come back. Throw them to us on YouTube, Instagram, Twitter, Threads, and TikTok, and Facebook, and we'll get to them when we get back. I'm Anjanette Levy. You're watching Law and Crime.
Ladies and gentlemen, your Los Angeles Lakers.
All right, y'all. Be sure to go ahead and hit that like button, man. You know, we're still here. It's still going down. They're still trying to figure out what's going on. You know, I need everybody that's in the building right now, hit that like button, man. We here right now live streaming, man. The YNW Melly trial verdict is going to happen on Country Ass Media. You know what I mean? So be sure to hit the like button. Be sure to subscribe, guys. Be sure to, you know what I mean, come a part of the family. You know what I mean? Hope everybody is doing great. You guys get in the comment section. Let me know, you know, who do y'all think, you know, what do y'all think is going to happen here? You know what I mean? Is YNW Melly going home? You know, Y'all get in the comment section and let me know right now. Is YNW Melly going home? Is he, is he just going to be, in prison? You know what I mean? Is he going to get the death penalty? These are just things that, we want to know. It's just one of them. It's just one of them things, man. I just got to know, man. At this point, I have to know. I just have to know, man. And I want to know y'all's opinion. So, we're looking in the comment section, man, and we're going to sit up there and see, what y'all think about this. All right? Y'all let me know, man. What y'all think, man? What's going to happen? Is he going home today? Also, man, look like we got Gym Shorts in the building. Shout out to Gym Shorts. We got Gym Shorts in the building. Gym Shorts said, hell nah. They better leave Fredo alone. Nah, for real. It's looking mighty crazy. It's looking mighty crazy today. I don't know what's gonna happen, man, but man, it's looking mighty crazy. Y'all get in the comment section. Y'all let me know, man. What's gonna happen here? What's gonna happen, man? YNW Melly trial live right now on Country Ass Media. Y'all hit that like button. Yeah, man. I see y'all done been hitting that like button, man. Shout out to everybody that's in the building. Hit that like button,
Welcome
y'all.
back, and thanks for being with us here on Law and Crime as we take your questions in the YNW Melly double murder trial. That jury in the case is deliberating now. They're back in the room discussing whether or not the state wins its case on the first-degree murder charges. There's a lesser-included offense the jury is allowed to consider as well. That's a manslaughter count that was added yesterday as they heard closing arguments, or before the closing arguments, I should say. So we are taking your questions. The jury finished listening to a readback of Travion Glass's testimony just a short time ago. So let's get to more of your questions and keep them coming into us as we await that verdict. This one is for you, Terry Austin. Jamer Lee from Instagram asks, why don't jurors have access to video of testimony while deliberating? It seems out of touch to have to listen to a readback.
That is such an excellent question. And in fact, the issue came up today. The jury wanted the testimony read back, and the defense actually argued that it shouldn't be read back, that they should watch the video because this is being live streamed by us. So it could be absolutely played back. But the state said, look, the jury instruction says that it should be read back, and that's what we normally do traditionally. And we looked at that jury instruction, and in fact, defense David Howard said, Judge, I'm reading the jury instruction and it says playback or read back. So the jury instruction is actually ready to go for modern day. And this is the best evidence. At the end of the day, Judge Murphy said, look, we're doing the standard charge. I'm not going to have them look at the video. It's not something that has been admitted into evidence, so they're just going to have it read back to them. And the judge actually said he looks at the word playback in that jury instruction to just mean playback any video evidence from the trial, not playing it back from a live stream. So at the end of the day, even though we have that modern technology, the judge just only allowed the reading back of that testimony by the court reporter.
You know, Michael Bryant, that makes sense to me because that's not how the jury first viewed that evidence. I can see, yes, we'll play back an interview, a police interview, or we'll play back a surveillance tape or whatever. But these viewers watched for themselves in the flesh Travion Glass testify. They didn't watch it on television. So do you think that was the right decision, or do you think they should just be queuing up the testimony from the Law and Crime feed.
I'm always big on the visual. I think they're going to get more out of it than they do a static readback. But here's the way I would argue it. If the testimony they want favors my guy, I want to see it. If the testimony they want doesn't favor my guy, then I say read it, because it's a lot less effective.
All righty. Let's get to our next question. Cynthia Dawson from Facebook. Michael, I'll throw this one over to you since I inserted one of my questions. Why did only one person out of a full car decide to testify that Melly got in? I can add to that too, but what are your thoughts on that,
Well,
Michael?
I think we know that it wasn't for lack of some effort. They were trying to get a hold of everybody that was there that night. And the question really is how hard they tried, because a lot of folks evaded their efforts, however those efforts might have been. So that's why we only heard from 2, and there could have been probably 3 or 4 others that were there that night. Police were not successful in corralling them or encouraging them to testify.
We do know that Jacoby Mills and Dontavius Withers, who were the other 2 people in that vehicle, I just want to add to this, were interviewed by law enforcement. Dontavius Withers, for his part, gave a couple of different stories about whether or not Melly was in the vehicle or not. So he certainly gave inconsistent statements on that point. Jacoby Mills was interviewed at one point in time, gave a statement to law enforcement. So why he testified or didn't, we don't know, but he said some things that were pretty incriminating to Melly. So there you have it. Our next question comes from Trez Anthony. I have a question. Did Glass also testify, Mina, and say that Melly had on shorts after the studio session?
He did. And that was that bombshell. It was the headline everywhere. All the hip hop blogs. Melly had a change of clothes. It was a big revelation, and he did testify. And now it really just comes down to, can you piece everything together? I think I heard Linda say this. You know, if Melly was home, just throwing it out there, because that's what Adrian Davis said, he might have changed into shorts. You know, I know when I go home, I call it outside clothes, right? If I'm wearing it outside, I don't want to wear it inside the house. So I change every time I go home. I just don't want to wear my outside clothes inside the house. So there's been some conversation regarding if him wearing shorts means anything, but that was a big deal in this case, that not only did Cortland have a change of clothes, but also Melly.
Both wearing different clothes, according to the testimony in this case. And we have video evidence in Cortland's case, you know, Cortland Henry's case. Swag Sternot, I hope I got that right. Swag Sternot from Instagram. It asks, is it common, Terry Austin, to get a guilty verdict without the murder weapon?
I would say it's fairly common. I think most people believe you have to have that quote unquote smoking gun. And in a circumstantial case, I think most people think it's very hard to find someone guilty. But jurors, they are very smart. They piece together, they use their logic, and they figure out what actually happened if you have enough corroborating evidence. So the point being, if you have those shell casings, if you have the trajectories, if you have all of the information from the phones, putting everyone in the same place at the same time, if you have cameras where you can piece it together, if you don't have a gun and you have all of that other information in a case like that, I do think the jury could come to a conclusion that there is a guilty verdict. But we'll have to see if there's enough evidence here for the jury to come to that sort of conclusion. What I will say, it is much more difficult when you don't have that weapon. So it's going to be hard for this jury.
We shall see. These knee, I think I got that right on Instagram, Michael Bryant. Can he be found guilty of killing one of them, but not the other one? Or if he gets found guilty, will he be responsible for both?
Yeah, it's very interesting, and it crosses over into the felony murder issue that we've talked about early on, and where the judge decided that was inappropriate because we couldn't determine which person died first. Bizarre analysis, in my opinion. But having said that, in theory, yeah, he could be found guilty of one without the other, but that defies logic. I mean, how would that exactly happen? I mean, talk about holes in the fact pattern. Now we got tons of them because there's just no suggestion that there was a second shooter or that somehow the drive-by maybe killed one and not the other. But technically, yeah, they could find he is responsible for one of the deaths and not the other. That would be bizarre.
Let's get to some TikTok questions now. This one's for you, Mina, and I hope that you've done your studying on the cell phone data. So if not, that's fine too. But that was a lot of information to process. It comes from Trey Joseph 23 from TikTok. Couldn't the phone have been given back to Melly when Bortland met back with them at Fredo's?
I mean, anything could have happened. We just don't know what happened. You know, the phone is a big contention here. Who had the phone? Where was the phone? Was it outside? Was it in Melly's house? Was it at Fredo Bang's house? I think that's the problem with this case. We don't know for sure, and everyone has a different interpretation of the phone evidence that is there. But I do think the prosecution did a good job of making sure that we know that the phones are tracking all together. And then also, outlining when the phones actually split apart from car to car. Did I get an A? Was that good?
I think you got an A. I think we need to keep in mind too, there was the text with the pin to Fredo. So if you're sending a pin to Fredo and Fredo's coming to pick you up on Miramar Parkway, then how on earth, you know, that's a lot to think about. How on earth are you sending a pin and then not having your phone and then finding it back at Fredo's after Cortland gets there? And then Cortland had already had all of his stuff taken at the hospital. They took his clothing and everything, and they seized the Jeep. So,
well, I think the timing is also really important because Cortland got to the hospital at I believe 4:35, and I think the pin came down, and correct me if I'm wrong, at 4:42. So to answer the question, you can't be two places at once. So by the time the pin was sent, Cortland was already in the hospital.
Hey, and Jeanette, I have a question.
I think you.
I have a question.
Yes.
How
of course,
far
Michael.
are we really in the not too distant future from saying, you know, there were texts, there were phone calls, somebody dropping a pin. It was AI. You know, there were no texts by any people. There were no phone calls by any people. There were no pins dropped. AI did it. That's who you're looking for, AI. I don't think it's really that far off before we're going to hear those kind of weird arguments.
I mean, I think you're probably right about that. AI terrifies me a little bit, especially when I hear about all these warnings from scientists who've been working with it. Yikes. So you may start hearing that sometime in the future. Who knows? Let's take a quick break. When we get back, we'll take more of your questions. Keep them coming in. I'm Anjanette Levy, and you're watching Law and Crime. Stay with us.
Whatever you do it for less at Harbor Freight. Quality tools, lowest prices.
All right. So that's where we at right now, man. That's just where we at right now. You can go ahead and look at the chat and see everything going on within the chat, man. And, you know, look at that. But in the meantime, in between time, y'all be sure to hit that like button. You know, be sure to hit that subscribe button. You know what I mean? Just want to make sure, you know, that you guys are family. You know what I mean? So hit that like button, hit that subscribe button. But I just want to know, to the viewers that are currently watching right now, what do y'all think is going to transpire? Is Melly getting out today? Like, that's really the underlying question. Is he getting out? We can sit here all day, but is he getting out today? From your opinion, we just want to know your opinion. You know what I mean? Is he getting out today? All right. You guys be sure to hit that like button, subscribe button right now. Yeah, do that. At this point in time, we're going to invite some of the guests into the chat or to the stream. All right. So I've went ahead and let me go ahead and get that pin in the comment section. I've pinned the link, so anybody that want to come up here and maybe you want to speak right now, be sure to hit that link, and you can hide your face. We don't need your face in the video. We don't need any of that. All right, we don't need any of that. But I just want to know y'all's opinion on what y'all think is going to transpire in this particular situation here. It could go either way at this point. One guy ended up asking a question, hey, is it likely that he can just be, charged for one murder, instead of, both murders? And, it is quite possible. Some people think that because there was no gun found that, Melly is just all of a sudden just, off the hook. You know what I mean? And it just don't work like that, guys. No, it don't work like that. Y'all can hide a lot of times we just need to know that it was some bullets, there. Just the fact that we got that, and just the fact that we know that, a story isn't matching up, it's gonna make it easy, without a gun. They don't need no gun to know that you pulled the trigger. That right there is a myth. Looks like we're back, guys. So let's tune in. Let's see what's going on. Let's go.
Welcome back. I'm Anjanette Levy. We're taking your questions in the YNW Melly double murder trial. We are in verdict watch. The jury is deliberating after hearing a read back of the testimony of Travion Glass, one of the witnesses for the state in this case, who was at the recording studio that night. So we're in verdict watch. Keep it tuned right here because we are going to have that verdict for you when it comes in. For Terry, I'm going to send this question over to you. It's from TikTok and it's from Reba9488. Is there cell data showing the phone location where the "I did that" text was sent?
Well, no, because the "I did that" text was sent after the shooting occurred, and it was messaging back and forth between someone and Melly, where he said, "I did that." I think it was Gibbons who was the other individual who sent that message to him. And the message was, "How are you? Are you okay?" And this was after the shooting. And then theoretically, we see Melly saying, "I did that." But I don't see those messages as matching up. I don't see one as a response to the other. It seems a little bit out of context. The prosecution believes that that is an admission, but the messaging was not related at all to the actual shooting, and it wasn't tracked as far as where the cell phone was at the time that that message occurred.
The next one is Big Pook _ from Instagram. What do you think the jury is thinking, being that they asked for that testimony, Michael Bryant? This is again about the Travion Glass testimony.
Yeah, I really just think it all gets down to the alibi, and I really am curious if they ask for Mr. Davis' testimony. That'll solidify that in my mind, that they are really focusing on whether or not Melly got out of that car, whether or not he was just at home when the phone rang and they learned about their friends' deaths. That's, to me, that's it. That's the second part of that puzzle. So to ask for his testimony in and of itself, yeah, maybe they were just curious about the change of clothes, because remember, he said, I don't know, and I don't recall more than he said anything else, and whatever you show me ain't going to help. So if it was just his testimony, then it was probably about the clothing change.
Mm-hmm. Let's get to the next question. Mac2K from YouTube, Mina asks, if Melly gets found guilty, will the alibi witness, Adrian Davis, be charged with anything for basically lying on the stand?
So I'm not an attorney, but I know enough to know that if they wanted to, they could, but the likeliness, I don't think it's going to be likely. But if the attorney, if you guys want to correct me, but from what I've seen before, they can if they can prove it. But I think what they're trying to do here are get the murderers, right? And not so much the liars.
Yeah, and you did a great job answering that question because they really don't do perjury very often. So good job with that one. Mrs. Navalta from YouTube, do you think that since the jury asked for the testimony of Mr. Glass and Mr. Kelly, that the jury could be leaning more toward a guilty verdict? Terry, do you have any feeling on that?
Well, yes, at first I did think that, because if you think about the testimony of both of those witnesses, one, Trevion Glass, he said Melly changed clothes and he did not see Melly get into another car. So that does favor the prosecution. And for Michael Kelly, he was the crime scene investigator. He basically talked about the trajectory of the bullets, and he was actually not on the stand that long, but the jury, I think, wanted to reiterate what he said and see exactly what it was that he said. And so both those things do sort of favor the prosecution. But when we heard the testimony of Trevion Glass, one of the things that went through my mind was they're probably trying to determine his credibility. And like Michael said, most of the time he said, I don't know, I don't remember, or nothing is going to refresh my recollection. The only piece of information that he really did say in my mind is that clothing. I don't think he really seemed as though he knew what was going on after, the shooting and whether or not Melly came back to Melly's house. He knew Melly came back to Frito Bang's house, but it didn't seem clear to me when they read back whether he went to his own house. So I think all in all, it's probably a wash. We'll see if they ask any more questions about testimony. And again, I agree with Michael. If they ask about Adrian Davis, then that is telling you that they're trying to figure out who's telling the truth. And they see that as two pieces of very crucial information.
Mm-hmm. Michael, really briefly, we have to hit this break here in about 30 seconds. Ebony Palmer from YouTube asked, if Melly was found guilty, does he still have a chance for an appeal, even though earlier the judge asked him if he was satisfied with his lawyer's performance, and he said yes.
Yeah, he'll have lots of appellate rights. And even the ineffective assistance of counsel, which is what that judge note alludes to, you can still make that argument, even though it was a weird thing to ask in open court there, I have to say. Won't affect him, though. He'll have plenty of opportunities.
Things always come up on appeal. They get new information or what have you. The appellate lawyers, if they are different, will find other information maybe that the defense attorneys at trial ignored. So you just never know. All right, guys, we're going to take your questions after the break for a little bit here. So stay with us. I'm Anjanette Levy. You're watching Law and Crime. We'll be right back after this break.
So y'all see it. Be sure to hit that like button, man. Y'all see it. Let's check in with the live chat over here and, see what everybody is saying over here. See what everybody got to say around here, man. Hit that subscribe button too. Everybody that is new, we want you guys to come back, so be sure to hit that live. That live, be sure to hit that subscribe button just so that you don't ever miss us, and you'll be one of the first ones getting that exclusive just happened breaking news. You feel? So look like they might have kind of chilled out for now. Look like they didn't kind of chilled out for now, and then we should be getting a verdict at some point in time soon. So you guys be sure to stay tuned, because y'all already know we're gonna be the ones to give y'all the news first, and we're gonna keep y'all in the loop every damn time. So yeah, man, y'all be sure to hit that like button, man. Hit that subscribe button, man, and let's stay in the loop, man. We got to do that. Let's stay in the loop. We're not done, Yeah, we're not done. I want you guys, that want to get on here and, maybe you want to say what you want to say about everything. Hit that link right there, and you don't even have to show your face at all. All right. And yeah, we'll be able to hear your opinion as well. So you don't even have to show your face. Some of y'all are like, man, I would, but I just don't feel like putting my face on. You do not have to show your face. You know what I mean? You can just get up on here and let us know what you think about this whole thing. Because I'm pretty sure, everybody would like to know your opinion, regarding this. Maybe you think, what I'm saying, YNW Melly is going to be, he's going to be out later on tonight. You know what I mean? Maybe you think he's going to be in the studio later on tonight. So y'all let me know. What do y'all think? You know what I'm saying? So we're going to wait on that. As you can see, we're looking in the live chat of the Law and Crime channel. I'm seeing Melly is innocent, not guilty, free my bro, guilty, 8-4 vote, death sentence. I'm seeing all type of shit. Somebody said they did it. Yeah, man. So, yeah, man, y'all let me know what y'all think about this, man. And hit that like button, hit that subscribe button, hit all of those buttons. You know what I mean? That's relevant. We want to know what y'all think, man. Y'all have no idea. I just really want to know what y'all think. Hold on. Let's go over here and just kind of look at the live chat a little bit. For those of you that don't know, it's over there. But it looks like they're back, man. So let's see what's going on.
Welcome back, and welcome to Law and Crime here on this Friday afternoon. We are on verdict watch in the trial of YNW Melly, whose legal name is Jamel Demons. The jury is deliberating, and they're trying to determine whether or not the state proved its case against Demons for the murders of his two friends, Chris Thomas Jr. and Anthony Williams, back on the early morning hours of October 26th of 2018. If convicted of those first-degree murder counts, YNW Melly faces the possibility of the death penalty under a lower threshold that was signed into law by Governor Ron DeSantis earlier this year. So he really is one of the first people, if not the first, to face the possibility of the death penalty under this new 8-4 threshold. It used to be a unanimous vote necessary to impose the death penalty. There is a co-defendant in this case. His name is Cortland Henry. He goes by YNW Bortland. He will go on trial for the murders of YNW Juvie and YNW Sack Chaser in October of this year. So stay here as we continue to follow the verdict. Also, we're taking your questions for a little longer today in the trial. So keep them coming to us on YouTube, Facebook, Twitter, Instagram, Threads, and TikTok, and we'll get to as many of them as we can. We have so many platforms now, hard to keep track of them all. Our next question for our guests comes from Ty from YouTube. Do you think the jury will have a hard time with the conviction, given the fact that the state never put the gun in Melly's hand? So, Mina, I'll send that over to you.
I think they're doing a good job of building what they think happened, even without the gun. I think that recreation was really critical with that. It kind of depends on what you want to believe, right? Do you want to believe that the medical examiner and the recreation of the crime scene, do you want to believe that? Do you want to believe some of the people that are witnesses? Particularly Adrian Davis, who says that Melly wasn't even in the car. I think it just really comes down to what you remember. There's so much information. We're getting text messages and pictures and contradictory witnesses. And it's hard to keep track of, especially as we mentioned with all the names. So I think this really comes down to what do you remember? And what makes sense to you? What's plausible? What's not plausible?
Makes sense. I think that's a perfect answer, Mina. Let's get to our next question. Get Black with Me from YouTube. Do you think since there was no weapon found that the jury might pick the manslaughter charge, Terry?
Well, I think there hasn't been a theory put forth for that manslaughter charge. We know that the prosecution asked for the charge. It's a lesser included charge for the murder charge for that first degree premeditated murder. And I think it was done to sort of have an alternate theory for that jury to consider. But even during the closing argument by Bradley, she basically said, there's nothing here to show or to support the manslaughter charge. So I don't think the jury is going to get to that issue. I think it's either going to be that first degree murder, or I don't think they're going to have any theory for that manslaughter. Remember, you don't have to intend to kill someone for manslaughter. You have to have an intentional act that ends up in causing the death of the victim. But what would that intentional act be? Were they playing with the gun and they shouldn't have been pointing it? None of that has been established in the trial. So I don't think they're going to get to that. And I think the absence of a gun in general isn't going to really affect that manslaughter charge at all. And Anjanette, I just got a message that there is another jury question that just came out. They haven't announced it yet, but I just thought I'd let you and the viewers know that.
Oh, thank you for that update, Terry. You're so on top of it down there. I'll be interested to see what that question is. Do you have any feeling or do you see any movement around there letting us know potentially whether or not this question will be read soon? I assume all of the lawyers are just kind of hanging out around there waiting for either a question or a verdict or what have you.
Well, that's right. I mean, initially the judge said 45 minutes, then he changed it to 30 minutes to come back. And I saw the defense team say, look, what's the time frame? Because you said 30, but you were ready before that. So they are hanging by the courtroom very closely, and they are down there now. I don't think they've read it off. I will also say, Anjanette, as we were leaving, there was another jury question that we haven't even talked about besides the testimony readback. And the jury wanted to know the exchange rate for meters to feet. And the attorneys all agreed, and the judge agreed that they should just let their recollection of what that testimony was just serve as the answer to that question. The answer hasn't been given back to them, but they will be told, whatever you remember, that's what we should go with here. They're not reading anything back for that. So this next question could relate to that, or it could be something totally new, but we should see that shortly.
Wow. This takes me back to running track in high school. 1,600 meters was a mile, 4 laps around the track. 400 meters was a quarter mile. oh, we'll see what happens with all of that. Maybe somebody back there ran high school track. Let's get to this next question. This comes from Malcolm Chandler from YouTube. Michael Bryant, 100K track. That's his Melly's manager. His phone and Melly's phones were both together on Pembroke and US 27, the crime scene. Is this why he turned in the phone to avoid accessory after the fact? We had that testimony about him having possession of Melly's phone and later turning it over to law enforcement who had a warrant.
Well, it was a good idea. And what his motivation to do it was, who knows? But yeah, it's certainly an important piece of evidence. Those phones, they've been quite the headache in this case. And so, yeah, I think it's just common sense. Unless he's trying to hide something, why not turn over that phone?
Yeah, most certainly. And they had that warrant. I read some court documents about the whole thing too. It was pretty wild. Let's get to our next question. Gavin_Davis 43 from Instagram. Actually, I'm going to skip that one for you, Mina. I don't like that one for you. Let's send you something else. From TikTok asks, hi, Law and Crime Network. Do you think that the prosecution is relying on witness statements? How do you view it, Mina? I mean, we heard testimony from many witnesses in this case.
I think they're just throwing it out and see what sticks. They're just basically putting everything out there, and anything that they have. So I don't think they're relying too much on witness statements. I think they have a plethora of evidence, and it's all different. You have medical examiners, you have people talking about cell phone data, you have the recreation of the actual car, and then you have an eyewitness. And then you have the lead detective. So I think they have a variety of different things that they've presented in order to try to, secure their guilty verdict.
Mm-hmm. Reba05 from Twitter. I think we've heard from Reba before as well. If the jury is asking about non-witnesses, could that result in a mistrial? I think she means, Terry, the fact that they asked about the name mixed up. Probably a mix-up of names, but if the non-witness has a connection to Melly and the person was not mentioned during the trial, then it seems a juror may have been doing the outside research. So could this whole name mix-up thing cause a mistrial?
I don't think it could cause a mistrial here because it seems fairly definitive that the name that they came up with, this Cortland Sutherland, was not a real person. So I don't think anybody was doing any research. No one got some other names from the outside. They came back and said, oh, we meant, Cortland Bortland Henry. So they just basically got the name wrong. And just getting the name wrong isn't a reason for a mistrial. It was clarified. That's the purpose of having these questions. You don't hear everything all the time. Even with 12 people deliberating, not everybody gets everything. So the system allows them to ask questions, and then the judge will talk to the attorneys and they'll figure out what the answer should be. So I don't think in this instance getting that name wrong means anything at all, except somebody didn't hear, or many people didn't hear exactly what it was. So no mistrial for that.
Mm-hmm. Let's get to another question here. We got a lot of really good ones coming in. Chosen One from YouTube. Why were the messages stating they killed all of them already and the picture was a target over his face never investigated? Could lead to the shooter. So Chosen One, Michael, is asking about messages stating they killed them in the picture with the target over his face. They had talked about
Counsel is just referring to jury counsel. After we went to lunch, I received one message from the jury signed by the foreperson, and it basically is the box is checked, requested view evidence, hyphen, rescind previous request. It was on stage. Jurors who requested to wanted to hear the testimony of Michael Kelly have rescinded their request. We apologize for any inconvenience, so they don't hear read back to Mr. Kelly and Mr. Kelly's. Second thing is when Dale was in there, I guess, trying to get them lunch or something like that, bring them a lunch. He received from not the foreperson, but a short note, it was folded up. Is that good? And it was folded up, and it was passed to him, and it says, are we allowed to have Apple Watches? Someone has one. It's not signed or anything, but that was the message that was passed to me. And that's why when we got the message, I try to get everybody to come back to and just talk about it.
Was that another jury? Oh, sure.
Yes. We're gonna wait for 1 second, so I want Gary in here.
Okay.
And then we just want to respond to the
Got the mic over here. Cause what? I can't even reach it with it.
defendant, this counsel, and the assistant state attorneys. So what I was sharing with you regarding the message that Gary advised me was that yesterday when we started, sent the jury to deliberations, Gary asked for all their electronic devices or phones, including smartwatches and Apple Watches. And in fact, one of the jurors has an Apple Watch and presented it to Gary, which he has it secured with all the other electronic devices. Is that correct, Gary?
Yes, sir.
And secondly, he's also indicated that when he viewed various jurors, he was unable or did not observe anybody wearing a smartwatch. Is that correct?
Correct. Yes.
So I don't know how you want to handle this. And, I guess that's one of the things you could talk over for a second amongst yourselves. And I also have a message here from the jury, another message. And it says, what if we can't come to a decision, question mark, everyone is stuck on which side they've chosen, signed by the foreperson.
So, I think we're prepared to the extent that the court is, I think we're prepared to offer our responses.
That's fine. If you're ready, Madam, you ready?
Yes, sir.
All right, go ahead.
I know the court's not going to want to hear this, but with respect to the first of the notes.
Excuse me, when we talk about the notes, we're talking about the one.
Okay, the first would be the Apple Watch. Okay.
The individual juror.
Individual juror, Apple. As far as that is concerned, my understanding of how Apple Watch works, at least how mine works, is that there has to be some proximity to a phone for it to provide access to the internet. I don't know if I'm wrong.
There are versions that selling and cellular capabilities.
Okay. All right, so I guess we need to inquire with respect to who that might be that has it. And it would just be, we would suggest that we identify who it is, we just retrieve it and keep it moving.
So I think on that, you can remember pass the note to your deputy, bring that potential particular juror out and ask who has it, so we actually know.
You know, I wouldn't want to isolate them. I'd want to bring up the whole panel and have the court inquire as to whether or not anybody has any remaining electronic devices.
But as part of the court's instructions in 3.13 indicate that if anyone becomes aware of the violation of these rules, which includes not having an electronic device they must inform the court. I think for record purposes, we just identify the person who has the Apple Watch and is removed from the room. We don't know whether there have been any other violations, perhaps someone looking up something online, unless we inquire further.
Thank you. You all done anything?
Well, two things, Your Honor. One, the person in passing up that note did abide by the court's instruction that Ms. Smith just referred to, but it doesn't say necessarily bring them out and single them out and expose them as a snitch. and I think we're jumping the gun by suggesting that if we find that somebody had an Apple Watch, they need to be removed from the room. The Apple Watch needs to be removed from the room. Is that what you're saying? Okay, well, we concur in that respect. As far as
This is my thought, respectfully. I just bring the jury in as a group, just let them know I have a message. It says, are we allowed to have Apple Watches? Someone has one. I don't know if this, they're talking about this. One of the jurors does have an Apple Watch, but it was taken away, or not taken away, but they presented to Gary when he asked for it the other day before the jury went into deliberations. He goes in and just retrieves all their phones and electronic devices, and they presented it to him. So maybe that. And I'll ask again, I'll let somebody have a watch on them now, or if you have a small watch, and just see what the response is. If they say nobody responds to it, a smart watch, then we'll take the next step and we'll see where we go from there. But I'm going to ask the jury as a whole if anybody has a watch.
Your Honor, with respect to that, the only suggestion that I would make would be for the court to inquire if anybody does have an Apple Watch. When they go back to the room, please give it to Gary, as opposed to them feeling castigated in front of the public.
I still need to know though, if somebody has a watch and they give it to Gary, I need to know, make sure they haven't used it. You know, because he's specifically, I instructed him they can't have it back. I don't know that I ever talked about smart watches or Apple Watches per se, but I know in the standard instruction which I read to them, told they can't have electronic devices, phone set. Make sure he collects everything, so, and he has it stored. So let me just take it one step at a time, and we'll see what they say, and then if we need to inquire further, we'll talk about it.
Okay.
All right? So just ask the jury to commit for a second. Yes. Oh, wait a second. I'm sorry. Did I mention this thing?
The third?
I got another one. Another question.
Aaron, at that point, I think it's appropriate to read the Allen chart based on that specific comment. I can print copies for the court and counsel.
Well, it says here, what if we can't come to a decision? Doesn't mean they're in impasse now. Everyone is stuck on which side they've chosen. So if they say they can't reach a decision, that's one thing, but this doesn't really say they can't reach a decision. It says, what if you can't come to a decision?
I think they're saying they have not, and what if meaning, what is the procedure that we follow now that we're in that place, as opposed to what if that eventually happens. So we interpret it a little bit differently, Your Honor. As to what we should do about it, I'd like to confer with co-counsel. As to the other, this is the part that I know the court's not gonna like. We have made a position, taken a position that the statements that were requested at the same time and should be read back at the same time. Now we've received a situation, or now we've come to a situation where testimony that by a state witness was put on, and I know we're reading tea leaves, but because we're in that position, we need to account for every eventuality and possible scenario. I would hate for it to be that the jury that has now rescinded its request for the other testimony has done so because they have now been either browbeaten or convinced of a certain position because they lacked the ammo in terms of Kevin's testimony to retort. So I know that forcing the jury now to read a transcript which they have said they don't need might not be optimal. And so in order to preserve our objection, I would not propose that, but I would move for a strike on that basis.
Thank you.
Thank you, sir.
So there's a motion for Ms. Brown, the state which we heard.
I want to make sure I understand. The motion for municipal trial is based on the jurors rescinding their request?
That's the way I understand.
Well, it's based on the fact that we did not provide them the two statements at the same time, and now a request has been made to rescind, the request to see one of them has been rescinded. So it's not the fact that they have rescinded, it's the fact that the court denied our motion to read them at the same time, and now that has resulted in them rescinding the request for one. So that's the basis, to be complete.
Thank you, Mike. What the state wish to respond?
No, not manifest necessity.
Thank you. Motion denied. All right, so what I'm going to do then is, and what do you want to do about the Allen charge? Does the state agree that minor cities
We've asked them to print it out so we can look at the Allen charge, if they could, and then we need a few moments to discuss it with the court's permission. I'm sorry.
Oh, print it now, that's okay. Just want to roll with it.
That's all fine, well and good.
Thank you.
Well, we still going. You know, it's still going down, guys.
And I don't think the prosecution made their case, so I'm actually not surprised.
So, Miguel,
I'm not sure what's going to happen here. But guys, we're still live.
who was there that night in one car doesn't remember.
Be sure to hit that like button. Be sure to hit that subscribe button right now. Let's just keep listening in, guys.
It's not a couple of other minor things, but does that tell you anything when you put that together with this latest question about, hey, what if we can't come to a decision?
Look, I think it seems like it's premature, right? Because we're only about 6 hours and change into the deliberations, and they're already asking a question like that. And they had testimony read back to them. And so I think they need to go back and deliberate more. I think this is premature. And I think there's something to be said about this being Friday and they're sequestered, right? They're not looking forward to not being at home, not having their own life on the weekends. And so they may be trying to see if they can wrap it up quickly, but I definitely think this is premature.
Yeah, I'm confident they're doing their job, but they're humans and they've been at this now for a long time, and this is enough already. Again, if the initial impression within the group is that we're just not going to come to terms on this. Let's go into court here for the moment at which that particular question from a jury member was asked.
Defendant, this counsel, the assistant state attorney. So what I was sharing with you regarding the message that Gary advised me was that yesterday when we started, sent the jury to deliberations, Gary asked for all their electronic devices or phones
including smartwatches and Apple Watches. And in fact, one of the jurors has an Apple Watch and presented it to Gary, which he has a security with all the other electronic devices. Is that correct, Gary?
Yes, sir.
And secondly, he's also indicated that
We're okay with that in total. In total. We are.
Do you ever wonder about the legal ramifications of using your hands or your weapon in self-defense?
Law, I should clear them up for you now. That should be my problem, not yours. I don't think anything about any question or any statement the jury has made so far implies that they're unclear about the law and they have a set of jury instructions there, so we would object to that paragraph. The fourth paragraph reads, if you disagree over what you believe the evidence showed, then only you can resolve the conflict if it is to be resolved. We would prefer that it says only you can resolve the conflict if in fact it can be resolved. The words, if it is to be resolved, that phrase has a certain sense of inevitability, which seems like it's urging them to resolve it. And so we would ask that to be changed to if in fact it can be resolved. The next paragraph we would like eliminated completely. And it says, I have only one request of you by law. I cannot demand this of you, but I want you to go back in the jury room, then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's view until each of you has had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistrial and will discharge you with my sincere appreciation for your service. I don't think we should be telling the jury how to go about the function of deliberation, and suggesting to them that they each get up in turn and give a dissertation as to what they think the weaknesses of their own position are, I think is an unconstitutional intrusion on the function of a jury in its deliberation, and we would object to that. The final line says you may now retire to continue with your deliberations, and we're okay with that. Excuse me.
Your Honor, I have a vague recollection of any modifications to that being a problem. I'm trying to read, I believe it's out of this circuit, 2015 Almeida v. State. I haven't had a chance to read it in full, but I have.
You're objecting to the change?
Yes, I'm trying to read through, because I know it's.
All right, guys, let's go ahead and just take the time out, just to hit the like button.
Thomas versus State, which is a Florida Supreme Court case 748 Southern 2nd 970, 10 point or citation point 978.
So this is like the longest verdict.
Similar situation arose in Young versus State, and it cites Young versus State, where the court held that the judge's mediation.
I'll get in the comment section, man. Let me know what y'all think about this.
I know that there's a lot of case law on just disapproving a modification of the Allen charge. The state's position would be that it should be read in total to the jury as to not comment on what portions or not. I think to isolate certain paragraphs would be truly suggestive and have a negative impact on whatever issue will happen.
Your Honor, I'd like to know if that case that you read concerns jury instructions at large or an Allen charge?
Allen charge.
It is an Allen charge.
Who asked for the modification, the state or the defense?
Probably the defense.
yes, Thomas, the defendant, asked for that Alan charge for the standard jury instruction after the jury deliberated. The standard Alan charge is not given.
This is crazy, man.
And it says that a modification can be or is error.
It says in Young versus State, we cited in the Thomas case that the deviation from the standard instruction by one sentence was error.
Okay. So it's all the texture, so we want a chance to take a peek.
Sure.
I guess it's done as well.
Well, this is my question though. The way I read this jury inquiry form, it states, what if we can't come to a decision, question mark. Everyone is stuck on which side they've chosen. That's the question. So are you telling me, both sides telling me that they interpret that the jury is deadlocked? It doesn't say that to me. It says, what if we can? It doesn't say we can't come to a decision. It doesn't say they're deadlocked.
The second part does. That we're stuck in our respective camps. So that's the declaration of deadlock.
If they agree, it's an indication there that.
So if both sides agree, this is interpreted as a deadlock and they're stuck. Is that what you're telling me? Both sides agree with that?
Yes, sir.
Yes, sir.
Then I'm going to read the Allen chart. I mean, I'm not modifying it. That's a standard that's been around for 40, 50 years. I'm not modifying it. State objects to any modification, it's not agreed. I'm not going to modify it.
Can we take a chance and look at the case law?
Sure, go ahead.
See whether or not there's some distinguishing language.
I'm going to print comments.
Thank you. Even though how I didn't say that. I apologize for this. That's no problem.
We're happy to look at whatever case you want.
Thank you.
1999 for Thomas versus State.
I don't have anything.
You gotta stay tuned, man. Look like we're getting somewhere right now. It's really looking like they're about to get ready for a decision here. So just stay tuned. Be sure to hit that like button right now. Subscribe button. I'm not sure why the cameraman would even have the volume down right now. We need to hear pretty much everything that's going on in the courtroom, but we'll let him have his little moment, with having it on mute, but we really want to hear everything that's going on.
In other words, the change wasn't as to the substantive instructions to the jury. It was as to whether or not the effect of their further deliberations. So in other words, it's giving them an Allen charge and then telling them, and even if you were deadlocked, I'm going to send you home, which is completely different from the substance of the charge itself.
And I think, and at least the way Thomas interprets Young, it's saying that the judge made that error in that was the judge's suggestion to modify the, and defense objected to the modification. So that's, yeah.
So I don't think I need to speak further to the distinction there, which is the defense saying if the jury is saying they're deadlocked and we've read them an Allen charge, and the Allen charge says that if you still can't, case over, sending them back in for another day would be an element of compulsion that would be unconstitutional. So we could see where that, but we'd like to see if we can distinguish in any other reasons.
Yeah, go ahead and hit that like button.
And actually, Allison wanted me to make this point, which is pertinent, which is that in that case, the defense was the one that objected. Here, the defense is requesting. So we would have waived our opportunity to object should the court grant it request.
Appreciate that, Jay Morris. We still here. You know what I mean? Judge getting tired. Look like he kind of know what he gonna do. But hey, man, we still here. We still trying to figure out, you know, what's gonna happen here, man. Y'all be sure to hit that like button. Shout out to Jay Morris. Look like Jim Shorts is in the building. Said they taking more time than the OJ trial. Most definitely, man. It's pretty long right here, man. It's one of them ones, you know. I think even some of the homeless people is outside, you know, looking at the screens. And
Or that explanation was that Thomas. No, I see it in Thomas. I mean, I see it in Young. That's in Thomas as well. It's the same issue. Okay. So yes, Your Honor, the Thomas case that the state cited was Thomas v. State, 748 Southern 2nd, 970. It's a 1999 case, Supreme Court of Florida. And that also cites to a state, Young v. State, which is 711 Southern 2nd, 1379, a 1998 case out of the 2nd District Court of Appeals. And the state has represented the issue that Thomas addressed. I'd like to just read some language here from Young that indicates that Young was treating the same issue. In the very second paragraph of the opinion, it says, the jury began its deliberations in this case near 5 p.m. on the second day of trial. At or near 9 p.m. it informed the court, quote, as a group we cannot agree on a verdict, end quote. The trial judge made the decision to give the jury an Allen charge. It is proper for a trial judge in a criminal case to give the standard Allen charge where it appears the jury is deadlocked. The trial judge also decided, however, that he did not want in this trial that night and would bring the jury back the next morning. So it's the same issue, which is we're going to give you an Allen charge, but it's not going to be effective because if you still can't reach the verdict, we're going to bring you back tomorrow. So it's the same issue in Thomas, and we think that's different from the notion that a Allen charge cannot be modified at all to suit the circumstances of a particular case. Here, I don't think there is any need to tell them about the law because nothing they've said implies the law. And we also think that it invades the province of the jury to tell them that they should each get up one at a time and explain the weaknesses of their position. That is not only counterintuitive to an advocate, and they're advocates for their respective positions. It's counterintuitive to an advocate, and I think it's an unconstitutional invasion of the province of the jury. They should conduct their deliberations and discharge their constitutional function as fact finders without our interference. So we would object.
State, anything else? So let me ask you this, how do you want me to, my thought is, I'm gonna handle this question first about who's got a cell phone, if anyone. I'll ask them that as a group, and then I'll read the second inquiry form as what if we can't come to a decision, and then I'll read the jury deadlock. I understand the defense's objection to it. The instruction's been around for over 40 years. Stood the test of time.
Thank you, Your Honor.
I'm not going to modify it.
Thank you, Your Honor. I'd just like to read this before the court. I understand the court has made its decision, but Mr. Adelstein brought something to my attention out of the Thomas case, which is a Supreme Court case. And it says, as noted, every Allen charge issue must be decided upon the particular facts and circumstances surrounding an individual case. So that goes to the issue of individuality and whether or not it should be tailored to the circumstances of a particular case. And we're taking a position that mirrors what the Supreme Court has declared, that modification of Allen charges is not foreign. As a matter of fact, the Supreme Court has directed that it should be tailored to the circumstances surrounding individuals, so that we maintain our objection.
Thank you.
Thank you, sir.
So you want to bring the jury in?
Yes, sir.
So stay tuned. Hit that like button. Be sure to hit that subscribe button, y'all. Yeah, man, let's go ahead and take care of that right now. If you haven't hit that subscribe button, hit it now. Look like it's about to get serious, everybody. We got Melly standing up.
Jurors entering.
Let's go. Hit that like button, man. Subscribe button, man. Let's go. Y'all share this. Let's go. Here we go. It's coming, man. What do y'all think is about to happen? Get in the comment section.
Let the record once again reflect the presence of the defendant, the counsel, the assistant state attorney, and the ladies and gentlemen jury. Ladies and gentlemen, two things. First, I received a note, or my bailiff did. It's not signed by the foreperson, but it's a note that was handed to him. It says, "Are we allowed to have Apple Watches?" Someone has one from one of the members of the jury. As I tried to explain to you earlier, all the electronic devices are basically, you're not allowed to have those in the jury room. So we asked our bailiffs, Gary, to try to collect them. Does anyone have an Apple Watch? Yes or no? In their possession? I asked the question. Does anyone have one? No. I see everybody raising their hands, or several raising their hands, showing they don't. All right, there's no Apple Watches. Thank you. The second thing I want to do is, based upon, I received this juror inquiry form that is signed by the foreperson, that reads as follows. State of Florida versus Jamel Demons, case number 19-001872 CF10A. Check the box, ask the following question. What if we can't come to a decision? Everyone is stuck on which side they've chosen, signed by the foreperson. All right. So what I'd like to tell you or read to you is an instruction. It's called Jury Deadlock 4.1. And it reads as follows. I know that all of you have worked hard to try to find a verdict in this case. It apparently has been impossible for you so far. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it is legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on the facts of the case. There are two things that a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is, as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict, if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back to the jury room, then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's views until each of you have had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. Ladies and gentlemen, you may now retire and continue with your deliberations.
Man, they need to come on with it, man. Man, y'all see Jim Shorts going crazy in the comments right now.
Step down, council may roll to the fence. We'll be in recess.
Thank you, sir.
So I guess they pausing, man. We taking just a quick break, see what's going on. They gathering more things. You know what I mean, presenting this and presenting that, and making sure this go through and that go through. So, it's a lot going on right now. But y'all let me know in the comment section. Does YNW Melly look bothered? Like, does he look like he cool right now? Like, to y'all that be analyzing posture and body language and things like that, y'all get in the comment section. Y'all let me know, man. Does he look like he's in fear? Does he look worried? Um, man, let me know. Jay Morris said, that he about to beat the case. I mean, that's just what Morris, Jay Morris said, man. What y'all think about that? Uh, like I said, man, we got Jim Shorts going crazy in the comments, man. They all on Melly's forehead, man. You know what I'm saying? So uh shout out to Jim Shorts. Be sure to sit up there, and get over there. That's where we have all of our sports news and sports topics and things like that. You know what I mean? So be sure to check them out, man. Jim Shorts. Uh yeah, man. What y'all think about this? Hit that like button right now. Uh hit that subscribe button right now. You know what I mean? You guys are more than welcome to come live right now with me if you like. We can watch this thing together. Y'all let me know. All you gotta do is just go to that link right there, and whenever you go to that link, you will be able to pop up. You don't have to show your face. Gives you the option to do so or not. And yeah, man, we can watch this together. Hopefully, they're about to sit up there and wrap it up, man, because like Jim Short said, they taking more time, than the damn OJ trial. You know what I mean? So you guys just stay tuned. Gonna go ahead and take this time to tap into the comment section and let you guys see that. Someone says mistrial, all charges will be dropped. A lot of not guilty, comments going in there. Yeah, I'm seeing a whole lot of not guilty, comments coming through, man. So y'all let me know. Y'all hit that like button, subscribe button. Do you think that Melly is getting out today? Let's just that's just the question right now. Do you think that Melly is going to be getting out today? Look like we're about to get back in it. Let's see. Yeah, that ain't happening on my watch. Yeah, I'm just seeing a whole lot of not guilty, man. You know, a lot of people are just really, as y'all can see in the comment section right there, man. A lot of people just, you know, they're saying not guilty, man. R.I.P. Melly, free Melly, not guilty. Welcome home, Melly. Uh, free the big goat. You know, really, everybody need to be over here. Y'all hit that like button, subscribe button, man, and share this video. You know, share it to Facebook right now. You know what I mean? There's somebody that would love to watch this right now. Be sure to sit up there, you know what I mean, and put this on Facebook right now. You know what I mean? Yeah, go ahead and do that. Yeah, man, I need somebody loyal, man, to go ahead and, you know, and put this on Facebook right now. I don't know, man. There's a lot of people that's thinking that, you know, Melly is going to beat this just off the strength that there's no murder weapon. You know, that's just what they think, man. They think that he has a really good chance because there's no murder weapon. What do y'all think the murder weapon is? Get in the comment section, man. You know, maybe you're going to see this later on. You know what I'm saying? Maybe you just got off work and now you're watching the whole thing and, you know, things of that nature. You wanted to watch the whole trial and things of that nature, man. Shout out to you that wasn't here, you know, while it was live, you know what I mean? But it's still live to you, you know what I mean? So shout out to you, you know what I mean? Be sure to like, be sure to subscribe to the channel. You know what I mean? Shout out to everybody that's in attendance right now, man, with Country Ass Media, man. You know, you guys could have been anywhere in the world, but you know what I mean? Y'all are tapped in, you know, right now to the YNW Melly trial. You know what I mean? The verdict is going to happen on Country Ass Media. You know what I mean? Yeah, man. So be sure, you know, to stay tuned. You know, if you want to, man, be sure to follow us on Instagram. We all over Instagram, you know what I mean? So you don't want to miss us. You know, Gym Shorts in the comment section. If you guys look, you'll see Gym Shorts. Gym Shorts, that's just where all of our sports news is at. You know what I mean? Constantly got videos coming every single day. You know what I mean? Trending YouTube channel is really going down. But you know, y'all let me know, man. What do y'all think is going to happen on today? Do you think that YNW Melly is going to be able to beat this? Do you think it's going to be, you know, some type of mistrial? Um, do you think he's going to get the death penalty? Do you think he's going to get life in prison? You know what I mean? You guys let me know what you think. You know, I really want to know what you guys are thinking. You know, if you see over there to the right, we got the comment section flooded. This is just what everybody is, you know, saying on right now. You know, so you guys are, you know, front row right now. You know what I mean? You guys are going to see what happens. You guys know exactly what's going on. This is in real time. You know what I mean? Yeah, man, we're in real time. You know, so be sure to get you some water, you know what I mean? Some good juice, some good, you know what I mean? Some good snacks, you know what I mean? You know, some of you guys, y'all are, you know, you be on that THC and CBD and, you know what I mean? Hey, light up your stuff or, you know, take a gummy, you know what I mean? But, we're here and we're live, you know what I mean? We're here and we're live. Maybe you know, you're on your healthy trail. Maybe you don't put, you know, any type of alcohol or smoke in your body. You know what I mean? Shout out to you as well. Hit that like button, hit that subscribe button, guys. YNW Melly double murder trial, man. This is crazy. You know, it's huge, man. You know, we've been at it for 6 hours, 46 minutes, and you know what I mean, 20 seconds, man. You know what I mean? We here. Some of you guys are big YNW Melly fans. Put your favorite YNW Melly song in the chat. You know what I mean? Be sure to put that in the chat right now. Yeah, man. Put your favorite YNW Melly song in the chat. Somebody said red room on my mind. Somebody said they here for the verdict. I think everybody's here for the verdict, man. Stay tuned. I know one thing, Country Ass Media is going to have that verdict. Right now we're locked into the chat, guys. Be sure to check out some of the content that we have. We ended up discussing the Larsa Pippen and Marcus Jordan, even after Michael Jordan ended up saying that he does not, agree with that particular relationship. Man, we covered that particular topic. Some of you guys are into sports. We covered the Draymond and, Jordan Poole situation, even showed the fight. We got that on here right now. A lot of you guys saw whenever Curry ended up, winning that championship, man. We got that on here right now. Magic Johnson, man, he ended up, pretty much becoming the first black NFL owner, as of yesterday, purchasing the Washington Commanders for $6 billion. It's a little bit of change on there, but $6 billion. He ended up, getting, the Washington Commanders. So shout out to Magic. We covered that particular topic as well. And Dan Snyder, which was the owner of the Washington Commanders before, Magic Johnson ended up getting that NFL team. There's some, sexual allegations, there. So we covered that. We even covered that particular allegation as well. So be sure to check that out. All of this is on the channel. You do not want to miss, any of that content. The Jaguars, one of the sports conditioners, one of those coaches, one of the conditioning coaches for the Jaguars in the NFL. He ended up coming out gay, yesterday, which is no problem, you know what I mean? But he ended up coming out gay, and we're showing support for him. Be sure to hit the like button, guys. We covered all of that on Country Ass Media, so be sure to subscribe to the channel. Go check those videos out. It's just going to get bigger and better. We have so many other things going, so many other topics coming. It's getting crazy. It's getting very crazy over here, man. So be sure, to hit that like button, man. Be sure to hit that subscribe button. All right. Yeah, man. That's mandatory. Really want to know what you guys think about this, man. Is it going to be a mistrial? I'm seeing a lot of mistrial comments, not guilty comments, mistrial. Somebody said Drake did it. Something is not making sense. This is crazy. Somebody said the rat shot 2 people, lock them up. I'm seeing a lot of guilty. I'm seeing a lot of stuff. I'm seeing a lot of stuff. I know y'all see this. Do you guys think that this is going to be a fair judgment here? What do you guys think about that? Do you really think this is going to be a fair judgment? YNW Melly, Florida versus Jamel Dimmons. Will he be going home and having a good night in a mansion, tonight? will he be getting out on today? Y'all hit that like button right now. Hit that subscribe button. I need somebody to go ahead and throw this on Twitter. If anybody want to sit up there, and show any support to me, all you have to do is just sit up there and my Cash App is there, Miraculous D23. All right. And that's how you show any support to me, like as of like right now. Maybe you want to be a blessing to me right now. If you look at the bottom there, my Cash App is right there. So Cash App, Miraculous D23. You can screenshot that. All right. And you guys can hit me right now. You know what I mean? And it's very much appreciated, guys. You guys hit that like button, man. The jury is deliberating right now. I really believe we're about to get, that judgment. I believe that's about to come up right now. We just looking in that comment section, guys. Somebody said he's guilty AF. And you know what that means. I can't do too much cussing, man, on the platform. Country media. And they're not gonna let me do all that. You know what I mean. So I got to kind of, watch myself here. But you guys hit that like button, subscribe button, man. We also covered the Takashi 69 Kodak Black. Ended up dropping a track today. We covered that. That video is dropping. Man, it's a lot. Boosie ended up, responding to Kodak Black for doing the song with, Takashi 69. So, that video is coming, man. We got that. So you guys, man, you gotta stay tuned, man. Gotta stay tuned. Man, that chat is going crazy right now. Shout out to all the viewers. Y'all be sure to hit that like button right now, that subscribe button, man. You do not want to miss any important content that we have coming to the channel, guys. Is YNW Melly going home on tonight? Y'all get in the comment section and let me know. Do you think that YNW Melly 'Melly' 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 '
going? Love it. Man, it's still going, bro. Yeah. We're going on TikTok. That's where we headed. Yeah, not bad. You're not bad. That's what I'm trying to tell you. You're not bad. What do you mean? Grab me another pillow. Grab me another pillow. Come on, bro. I got shit to do. I don't want to be doing this all day. In case I need to say something to the chat. No, we gotta be prepared, bro. I'm live. Damn thing. I don't want you to say yeah. I don't want you to. Man, they need to hurry up with this, man. Golly, 7 hours. All you need is all you need is a what's the name? A dryer. Dry it. And then that's it. Yo, yo, yo.
on behalf of us, let me apologize if I have, or we have offended any of you. And I would ask you, I would plead with you, if I or any of the other individuals have done anything to irritate you, don't take it out on this young man. Still hold the burden of proof to this table. Now, why do they have the burden of proof? Because they are the state. They are the government. As we learned in this case, they have the police department of Miramar. They have the Broward Sheriff's Office. They have the DNA labs. They have experts, the FBI. They have everything at their disposal. And that's why our system of justice is different than anyone else in the world. We recognized a long time ago that when the government accuses somebody of a crime, they have the money, the resources, and the person power to attempt to prove to you all that a person has committed a crime beyond and to the exclusion of every reasonable doubt. Now, how do you go about doing it? And before I get into that, first of all, let me also thank you, because we have interrupted your lives for it seems like months. And we have put a horrible burden on your personal lives, your family life, and what have you. And all of us applaud and thank you for your service. You folks have gone way beyond the call of duty. And I think we all recognize that. But how do we go about determining, and I shouldn't say how do we, how do you folks go about determining if the state of Florida has proved their case beyond and to the exclusion of every reasonable doubt? Well, the judge just gave you that instruction. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. Remember, we just got to show up. And how does a reasonable doubt occur? Well, the judge has told you. It can come from the evidence itself, a conflict in the evidence, or a lack of evidence. You don't need all three of these areas. But I suggest to you folks that we have a reasonable doubt from the evidence that has been presented, that there is a conflict in the evidence, and there's a lack of evidence. This is an unusual case, kind of like the medical examiners. The two medical examiners said it's unusual because normally you can't tell what shot occurred first, second, and third. And the chief medical examiner came in here, Dr. McDougall, I think, and told you it's only happened to her in her entire career, I think 2 or 3 times, that she could tell you which shot occurred first in this case. So, knowing that, let's look at what the state presented. But before we do that, we can agree upon a couple of things that are not in dispute. They said that Matt Melly is a talented music artist. We agree with that. At the age of 19, based upon the evidence, he was making more money than probably everybody in this courtroom, including us. Number 2. Oh, I'm sorry. I apologize. You okay? Usually the judge stop me immediately. Number 2 is that Cortland Henry changed his clothes before he went to the hospital. That's what they said just 10 minutes ago. Number 3, that there's absolutely no eyewitness
that will implicate this young man to this crime, these crimes. Number 4, they talk
On the first day, I did $12,000, and that
that I'm kind of shocked about. But it's, you don't know. So let's put the 100+ exhibits to the side for a moment. The state called 26 witnesses. I think I counted. And I suggest to you that you should look at 11 witnesses very carefully. And why do I say that? Because when you look at these 11 witnesses, you will find out that there's a conflict in the testimony, that there is a lack of testimony, and the third way is from the testimony itself. The first one that I would like to talk about well, before I talk about the first witness, I want you to remember one thing. On October 26th, that day of the shooting, we learned immediately that that Jeep was taken to a secure area, and it was searched for over 15 hours by 2 crime scene technicians. And you heard how they pulled out the evidence. They got some foam, some projectiles, I think a can, everything, and photographed the vehicle. Now, why is that important? Because that vehicle was searched. You okay? Want to take a break? That vehicle was searched again months later. But it didn't stop there. Because about 3 years later, miraculously, even though it was searched for hours by crime scene technicians, Sergeant Williams comes into the scene at the request of the state of Florida, this particular prosecutor right here, and miraculously he finds additional evidence, 2 projectiles and a bloodstain that obviously everyone else missed. That should tell you something about the quality of this investigation. That should give you a clue as to what's going on in this case. What happened was, once they got the surveillance tape of individuals leaving the studio, They knew that Cortland Henry, Williams, Thomas, and this young man got into the Jeep. It's shown on the video. In the Mitsubishi were Adrian Davis, Patrick DeLoach, Trevon Glass, and I'm missing one other. Whoop, pardon? Withers, Dontavius Withers. And we know that on October 26th, when Moretti saw that surveillance, Cortland Henry identified all of them. And in fact told them that he lives at this young man's house. I made a mistake. Jacoby Mills was in the car. It was Jacoby Mills, Adrian Davis, Trevon Glass, and Dontavius Withers. Okay? I can't keep the names straight. I'm lucky if I can remember my own name. That's why I haven't written it down. We know that Moretti identified all 8 people that left the studio on October 26th. We also know that Moretti knew where this young man lived, along with all the other 7 people that left the studio. We all know that, according to the state, Cortland Henry lied to the police. And we also know, as the investigation progressed, that Cortland Henry had blood matching the victim on his clothes. And he also had GSR, or gunshot residue, on his clothes. If that were true, and you saw the pictures of the Jeep, all bloody, blood all over the place, and we learned that you could spray and determine if there was blood right here on the carpet, even though you don't see it, why in the heck don't you get a search warrant for the house? Why in the heck don't you? Don't tell us we didn't know where he lived. Don't tell us it was months later, because they go into the car 4 years later and do this. So why don't you do it? Because Detective Moretti and the Miramar Police Department, as everyone has said, lacks the experience and the training. We don't have to do a darn thing, folks. We don't have to do a thing. But let's go into the 11 witnesses now. The first one, and they mentioned it, George Bello, the manager, the head guy, the gun and tool mark unit of the entire Broward Sheriff's Office. And he tells you, after we get a great education of guns and projectiles and casings, we have to bring out the fact that can you tell or determine the distance between the shooter and the victim? Can you tell us that with all your experience? And what does he say? I can't do it unless I have the weapon, unless I have the ammunition, because ammunition, the weight of ammunition could change the distance. And you have to have the weapon in order to do that. He cannot even tell us if it was one gun, two guns, or more. He's honest. He tells you that without the weapon used, I cannot place the shooter to the victim, or victims in this case. Now, why is that important? Because a reasonable doubt can arise from a conflict in the testimony. If you believe George Bello, and I suggest you should, then he totally contradicts all the testimony of Sergeant Williams, who comes in here 4 and 5 years later and says, I can tell you where shooter one was, and I can tell you who the shooter is. You talk about a conflict in the testimony? It's one or the other. It can't be both. And he tells you, in addition to that, that the environment has to be considered. Now, Williams tells you he goes out to the scene some 4 or 5 years later and has no idea, nor did he even check the terrain, the environment on that particular morning hour. So you got to believe one or the other. You can't believe both of them because they are in direct conflict with each other. But let's go further. The next witness that you should consider is FBI agent Brendan Collins. He is an expert in tracking phones. He is not only an expert in Broward County, but he's an expert, and his team have been specially trained to map phones, not only in this country, but anywhere in the world if he's called upon. They brought him in. And what does he tell you? This expert. I cannot determine precisely the location of a phone. I cannot say 100% the phone is in, and you saw the band, it looks like a banana. He says, I think it's somewhere within this area, but I can't be 100% sure.
This is State Farmers, Jamal Denman, President is the defendant's counsel and assistant state attorney. The jury is in the jury. I have another question or juror inquiry form that says, ask the following question. Ray Exhibit 116 hyphen times listed, paren start and end, close paren, marked as UTC-4. Does UTC-4 reflect that 4 hours have been subtracted already, or does subtracting 4 hours from start and end times need to be calculated? Signed by the former.
You can answer yes. I think we need to just tell them to rely on their recollection of the test.
I don't think I can answer. I agree. So,
yes.
counsel, I just answered this way. So you want to rely on your recollection of the evidence tonight for my answer. All right. Any objections?
No objections, sir.
Thank you.
Thank you.
We're recessed.
Recess.
I'm so fat. Brendan, you're not fat. It's the shirt.
This council, the Assistant State Attorney of Jersey, council, my understanding from talking to our bailiffs is that because of the sequestration, they need to take the jury to the hotel. Otherwise, they missed it or something like that. At 5:15, you said the latest. So it's 5 or 10 minutes from now, and well, less than 5 minutes from now. In any event, what I want to confirm with you again is that they're going to take the jury. They'll excuse them now. There's no need for me to bring them back in the courtroom, correct? Correct. Yes, sir. So they'll just take them to the jury room, to their hotel room. They'll feed them tonight. They'll make their phone calls as they typically have done. They'll make phone calls to stay observed and things like that. And then they're going to be back here after breakfast tomorrow morning. They'll be back here.
Between 8:30 and 9.
Between 8:30 and 9. Again, my question is, can I do it like today, where you're the attorney, you're not involved in it? You know, we'll call you when we need you, and the bailiff just puts them back in the jury room, and you'll be on, let's say, a half-hour notice. Is that good for everybody?
That's good. You're okay with that? That's good.
Yes, Mr. Davis, you understand? Yes, sir. All right. So
The 2023 Kia Sportage.
All right, well, I know you were here this morning, really, then you had to run this delivery, but you were here first thing. But in any event, we'll do it the same way, and your co-counsel, they'll get here within a half hour, all right?
Yes.
He's on his way. All right, counsel, is there anything else to discuss then?
Yes, sir. Thank you.
All right, thank you. It's 5:15. Tom, you want to take that then?
I think you guys. Get out. Yep.
Well, looks like, we're not going to be getting what we're looking for today. And, that's the part that really sucks. Because, in my opinion, I feel like for as long as, this shit is taken, you know what I mean? We should have already kind of got something, man. And I just don't think we're going to be getting it today. It talks about, hey, how we're going to be back tomorrow between 8:30 and 9 a.m. to resume. And so court on a Saturday, man, is looking like what we have going on, man. Court on a Saturday, man. So, even after 9 hours, we still do not have a verdict. And so that's just kind of what we have, guys. So, this is live right now. We're in real time. As you can see, we've been filming pretty much all day. Be sure to hit the like button, subscribe button, and we'll just see what else we got.